Well, good morning. Good afternoon to some of you that are joining us today. Thank you so much for joining us at the most common jury selection mistakes and how to avoid them webcast. My name is Mike Weathers. I'm going to be moderating today. You might recognize me from some of the previous webcasts we've done or my work at the Daily Metropolis as a news reporter. I'm joined today by Doctors Miles and Hutton, both of whom are specialists that work with DecisionQuest. Dr. Hutton, can you give us just a little bit about yourself?
Sure, I'd be happy to, Mike. Thanks. Let's see, my educational background. I have a doctorate in psychology from Columbia. I worked for a few years as a research psychologist, did a lot of peer-reviewed academic articles, and then I decided I wanted to get into the legal field. So I've been a consultant for over 20 years now, doing all kinds of cases all over the country. And I do a lot of different things, jury research, but what I'm most happy to talk about today is jury selection.
Awesome. Dr. Miles, do you mind giving us the elevator pitch?
Sure, absolutely. Dr. Stuart Miles, and there'll be some confusion because Miles Hutton and Stuart Miles, we get each other's email all the time. But,
yep, I used to get your paper mail way back, right?
That's right. And so my background is similar to Miles. I've got a PhD, and mine's in social and personality psychology. And I was on track to be a research psychologist in a university like Miles, but I fell into doing trial consulting, and I never looked back. That was around 25 years ago. And Miles and I, what we do is very similar. I head up the Louisville office of DecisionQuest, and I'm a regional vice president of the Southeast and Southwest, but work all over the country like Miles does. And most of the work that I do is jury research, and we do a lot of jury selection as well, which is the topic of today's talk.
Fantastic. Thanks so much. I am proud to call you both colleagues and glad I have you both to lean on, not just today, but overall. Okay, so let's get started. We're talking about jury selection. So can we just start with a macro approach? What is your overall approach to jury selection? And I'm going to leave it up for either one of you, whichever one wants to get started, but I'd love to hear from both of you on this one if I could.
We'll go beauty before
I'll jump in. Oh, go ahead, Stu.
No, I said beauty before age, so you can go first.
Oh, all right. I'm glad I let you talk then. Yes. Yeah. So no. Basically, our philosophy, I think, tying this into the title of the talk, is we are interested in deselecting jurors. That's often different than how attorneys think about it. They think in terms of common mistakes, sometimes attorneys feel that they can pick the best jury. Unfortunately, the way things work is with only a limited number of challenges or strikes, and also a limited amount of people you can walk off for cause. It's really the case that what you're looking for is to get rid of those jurors who have a real closed mind. No matter what you say, they're not going to be receptive to your case. So that's really our focus.
Yes, and agreeing with Miles, the challenge is, of course, being able to get rid of all of them. And unfortunately, in most cases, you end up with a few on the jury that either through cause or through your peremptories you couldn't get rid of. And a big part of our job is kind of prioritizing which ones on that list need to be on the strike list and which ones that we can live with. And leadership, which we'll talk, I'm sure, more about later, plays a big role in that.
Yeah, I mean, we might as well jump in now to talk about that, Stu. I mean, right. So you'll have two bad people, right? Bad for your case, and you don't have the peremptory challenges to get rid of these folks, right? So what do? And as Stu correctly identified, you're looking for leaders. Those would be the priority to get rid of, leaders that are against you, right? If somebody's bad for you and they don't open their mouth in the jury box, then that's not so terrible for you, right? But if there's somebody who's a leader, you could be in trouble. They could motivate everybody to go against you. So what kind of things are we looking for with leadership? Well, with leadership, we're looking, people who, if you have the opportunity to do a social media search, in advance or opportunity to ask them questions about this. You're looking for somebody who's involved in a lot of different civic organizations, has leadership roles in that. You're looking for folks who have expertise in the area that the case is about. So if it's a patent case, say it's a patent case about computers, somebody with a great level of experience with computers, you want to watch out for that person if their overall view is negative towards your client. You want to look at folks that do a lot of public speaking, right? So teachers are often a good leaders, so you kind of got to have your antenna up for all these kind of things when you're trying to decide who to strike.
And I'll add to what Miles said, what's even more dangerous than somebody who has actual knowledge on a topic are people who think they have knowledge on a topic. Because if somebody has knowledge, you can maybe predict which way they're going to go based on the facts of the case. And Miles will tell you, we have some cases where having people with knowledge is good for us, and other cases where having knowledge is bad for us. But what is bad for us almost always are people who think they have knowledge, because there's no predicting what they're going to say. And so those are the ones that are really important when we're asking those questions of people to kind of ferret out who they are. And again, identifying leaders in general is important. And then, as Miles said, figuring out where those people fall in terms of helping or hurting us. And my general rule, Miles, is, I'm interested to see if yours is the same. If somebody's a leader and they haven't proved otherwise that they will be helpful to my case, my general rule is to get rid of them. So if they're a leader, they're presumed to be bad until proven otherwise.
Yeah, it's all about the number of strikes. I mean, I agree with you. I worry about them more and have more sleepless nights about those folks. Sometimes you got to roll the dice depending on the number of strikes. The other thing I look for leadership is actually how they present themselves during the oral voir dire, right? So if they seem very charismatic, very polished, act like they know something even when they don't, those types could be a leader on your jury. So yeah, I think we're on the same page on that.
Yeah, I mean, so you guys have both mentioned a couple of things, actually kind of getting it, having information and identifying some different things about these people that we are vetting, which is really kind of that big portion of the process, right? How do you do it? How do you go about getting the information that you need, or identifying those things so you can pick out which ones are leaders, which ones are going to be helpful or harmful to the case? How?
Well, I'll lead off, Miles.
Go ahead.
And I'm interested to see your thoughts on this, because Miles and I have never picked a jury together. Miles, while we both work all over the country, I think Miles does a lot more work in the Northeast than I've done. I've probably picked more juries in the South and Southeast, Southwest than Miles. And so, there might be some interesting regional differences, but one of the big things that I have to impress upon attorneys, and which is really hard to do because of just social norms, and it's why this technique works, is it's really hard to get jurors to talk. They generally do not want to talk. And so goal number one, and talking about, the title of this talk, dealing with mistakes, a big mistake I see attorneys do is they ask a question, they wait about a heartbeat, nobody responds, and they move on to the other question. And the big thing you have to do is you have to create this social discomfort to get people to talk. And you also have to, another big mistake I see is that people try to convert jurors and change their minds, which is not going to happen. And what that does is, if you get one person talking and then you kind of go after them trying to change their mind, it shuts everybody else down. And so what you try to do is you ask that question and then you pause. And I tell them to wait 7 seconds. And it's amazing, if you just have 7 seconds of silence, somebody in that jury feels the social pressure to fill that silence. And then it's all about getting that first person to talk. If you get that first person to talk, and then you treat them like a hero, no matter what they say, especially if they say something bad about your case. You're like, Mr. Jones, I want to thank you so much for being honest. Both I and the other side, it's so critical And this system doesn't work, Mr. Jones, unless we have people like you. You create that silence, you get that first person talking, you make them a hero, and then everybody else is like, oh, I want to be a hero. And then they start sharing their opinion. And it's all about creating that atmosphere to get people to be honest with you about how they don't like you. And that is a skill that takes time to learn.
Right, I completely agree, Stu. The other piece I would add is, you let them know it's okay to acknowledge prejudice against your client, right? So if you have the time, I sometimes give different examples, like it's very important, to find out, in order for the process to be fair, who's the right jurors for this case, like who can start off completely even, and I give an example like, I hate the Yankees, I'm from Boston, if I was, judging a sports case, I could try my best to be fair, but, if it was somebody involving the Yankees, I'm sorry, I might be just a little, over the line, the Boston Red Sox or any other team might start off just a little ahead. Or if I was doing a pie eating contest and for the best pie and I hated apple pies, it's just not fair. I could try my best, but you really gotta, in order to be fair, in order for this whole process to be fair, you really need to be open and honest. And there's no shame in, going against, saying something bad about my client or about me. It's not going to hurt my feelings. So those are the kind of things, the permission to acknowledge kind of prejudice against your client, and make it feel, like Stu said, that it's not a bad thing. In fact, it's praiseworthy, right? You're being really honest. So that's something that is getting information in the oral voir dire. To step back a little, the way we would want to get information in general is, if we have the opportunity, we try to get a written questionnaire sometimes. You can get a lot more detailed responses. And then also when you have a large group, you don't have time to get as into it as you would with an individual written questionnaire. The other thing is, if we can get the names in advance, we often do social media searches of the folks. So those are other ways to get information. And then one quick thing, the way you want to organize all this information is you should have some kind of juror profile in advance. So what do I mean by that? You should have a kind of profile of what are the good characteristics for a juror that would be favorable to you, that's predictive of those that would be favorable, and what are the characteristics predictive of a juror that's not going to be so good. So you kind of know how to organize this massive information when it comes in.
And adding what Miles was saying, and again, going back to big mistakes people make, is that there's a I'm not going to call it a desire, but there's a proclivity for attorneys to think that certain demographics are going to be predictive in certain types of cases, when my experience is, Miles, that demographics rarely are predictive. And that's a big mistake people can make, because it's just, life and trials are way too complicated. And people are not as homogeneous based on race, income, political affiliation as we'd like to think they are. And really the only time that you can really fall on those as things to use as a choice outline is when you've done a large in sample and you have some data to back that up. Would you agree with that, Miles?
Yeah, so I mean, I think what Stuart's referring to is jury research, right? So what we typically do in jury research, or even a juror profiling study, is we see how people answer and what their demographics are and how they correlate with their final verdict in a mock trial, or if it's a juror profiling study using a case vignette. So then if you have enough data, you can say, oh, older people are good or bad for us. But what too often happens is, to be honest, an attorney had a bad experience with an older juror on the last case, and all of a sudden anybody over 70 is terrible for me, and there's just not enough data for that. So the kind of things that you can really bank more on is attitudinal questions about attitudes that relate to your case, and what I call experiential questions. So those are questions, say you got a contract case and somebody's broken a contract, or they say, I have had somebody break a contract on me. If your client has broken a contract, it's a decent bet that you don't want that person, because they're going to be resentful, about the fact that somebody broke a contract on them, and they may project their own experience onto your case. Again, it's always better when you actually have data, but if you don't, then, you can still use common sense and your experience with similar cases, which is what Stu and I do.
Right, and that is important because in any one jury selection that Miles and I work on, even if we've done research on that case or haven't, we've worked on dozens, if not hundreds, of similar cases, and we draw on that experience in both drafting the questions and assisting the attorney in picking those questions. And I'll just kind of wrap up, or maybe not wrap up, you might want to talk more about it, Miles, but going back to demographics, and again, I bring that up because it is one of the more common mistakes I see attorneys make, is that even if you do have research, and usually it takes, it takes dozens and dozens of people, because usually you don't often find demographic relationships, and if you do, you need a lot of power in that study. By power, that
Right, not that powerful, correct.
Right, so it usually takes more than 24 or 36 people, but even when you find it, generally those are used as tiebreakers. Wouldn't you agree, Miles? The attitudinal things that are more directly connected to the strength of those attitudes that might persuade a juror are going to be more important than any demographic features that they might have.
I would say 98% of the time, yes. I mean, sometimes I do juror profiling studies that has 400 people in it, and then you can actually look at the predictive power, and once in a while demographics are high up there. But yes, 98% of the time it's very weak prediction with demographics. And the reason why attorneys try to emphasize it is that's often that's all they can get at sometimes. Exactly. You see somebody with red hair up on the stand, being questioned, and they're terrible for you from their answers. That's what you identify. That's what you can easily discern. And I agree. Demographics are certainly on average way overemphasized by attorneys.
So I admit, as we're having this discussion, the first thing I thought of as we started talking about profiling prospective juror, literally the first thing I thought about was, okay, well, do I need a juror that's over 55 and is a woman and leans liberal, and that demographic was the first thing that came to mind for me. So I guess it makes sense, right? This is why you two are the experts. I appreciate you educating me today, and the rest of us. So you've mentioned a couple of different sources of information, right? We've talked about asking questions. You talked about oral voir dire, right? We've talked about social media. Can you just explain or elaborate just a little bit on what we're getting from where and how? I mean, particularly, I'm really interested to know how we're getting things from social media.
Yeah, so with social media, this is another maybe common mistake. Attorneys are often reticent to ask for things, right? So what we'll encourage the attorneys to do is ask the clerk of the court, can I get the juror list of the pool in advance? A couple weeks, ideally. And, they're often surprised, by being able to get that list. So then what we'll do with that is we'll search social media. So things like Facebook, LinkedIn, Twitter. Also, we have a subscription database that can look at things like criminal record, bankruptcies and liens, political party affiliation. So we take this information and we already have a profile, and we can use that to look at what factors may show whether they're more likely to be favorable for us or favorable for the other side. The best information that you can get, and I think Stu was going there before, is that's a good supplement, but the ideal information you can get is a robust voir dire questioning process in the courtroom. That's really the best. And there's certain kinds of questions that you can ask that really are able to get specifically at the attitudes of your case. But we don't live in an ideal world, right? So often, voir dire is limited. The judge, especially in federal venues, the judge may even just ask the questions him or herself and say, okay, I'm going to ask these 4 questions. or they may let the attorneys ask questions, but strike a lot of the questions. So social media is a good supplement in terms of jury selection, but ideally you would get a real robust voir dire process as well.
Dr. Miles, you got anything to add to that?
Writing notes on Miles.
What's that, Stu?
I said, I'm just writing down notes. You're giving me some good thoughts to follow up with. Well, and also this is another tie into that, Miles, is that, and this has been my experience, is that the people who usually end up on the jury are the ones who didn't say anything. Because generally, if somebody says something, one side or the other isn't going to like it, and they're going to strike them. And so that's another big thing I try to, stress with the attorneys. You got to get everybody to talk. No matter how hard that is, if you have the time and the judge is going to let you, get everybody to talk, and then also identify certain either life experiences, characteristics, what have you. And if anybody says yes to those are people that you're always going to follow up with on all the questions, all the important questions. But yes, getting everybody to talk is critical, because has that been your experience, Miles? Usually it's the people who don't talk who end up on your jury.
Yeah, I mean, the converse of what you're saying, Stu, is, I go to cocktail parties or whatever and say I'm a jury consultant, and folks are like, how do I get off a jury? And I say, just talk.
Yeah.
Because you'll say something that the other side will not like, so don't clam up. So I agree. You want to get them to talk. And the other thing you want to do that folks sometimes forget, attorneys, is you want them to talk in the right way. You want them to disclose stuff that shows if they're a strong juror against you, right? You want the questions to be framed so you can find say you're the plaintiff, so you can find the strong pro-defense jurors, but the other side can't find the strong pro-plaintiff jurors. So ideally, I mean, the gold standard of questions for me are kind of slanted attitudinal questions. You can't always get those in. The judge may object the other side. But, let me give you an example of what I mean. So, I don't know, say you're representing a large company in a contract case or something. You would want to ask some kind of question like, do you think large companies very often take advantage of small companies, right? So the people who are going to answer yes to that, if you are going to be those who are strongly pro-plaintiff or against the large company, right? And that's not going to reveal much to the other side in terms of, who they want to get rid of. I'm sorry, they're going to be strongly pro small company. So that doesn't reveal much to the other side of who's strongly pro large company, right? So you want to slant it so the questions are ones that, by people saying yes, that shows that they're very against your client. That's kind of how you want to slant it. Did that make any sense to you, Stu?
No, it's perfect. And actually what you want to avoid is people are reluctant to say something bad about you or your client, right? But if you ask them something that might be helpful to the other side, if you ask them the converse, as Miles said, you don't want to ask them a question where the answer is going to help the other side, and they actually might be more likely to be honest with you about it than they would be if, say, the plaintiff were asking it. And so again, you have to, if you get away with it, slant it in a way where you're not doing the work for the other attorney or the other side. And going back to surveys, Miles, because again, I'm just making notes. Would you agree? Because it's been my experience that surveys are not always what our clients want. Sometimes one side benefits more from a very exhaustive survey than another side does. And so that's, when I'm working with a client and they say, I want to work with you, I want a jury questionnaire, I'm like, well, are you sure you want a jury questionnaire? Let's talk about that, because sometimes the other side.
So sometimes you don't want a robust voir dire process, right? Exactly. So, I'll give you an example. Like, I'm sure you know this, Stu, but for you, Mike, say you're representing, a small individual who, had a really bad reaction to a drug, to a medication, and a large pharmaceutical company manufactured that drug. You may not want such a robust, voir dire process in terms of an extensive written questionnaire and stuff like that if you're representing the individual plaintiff, because the large pharmaceutical company has a lot more bad jurors to find and detect than the individual person representing the individual plaintiff. So why make it easy for the pharmaceutical company and say, oh yeah, we'll agree to a 50-page written questionnaire so you can find all the people that hate pharmaceutical companies. So even though it's less business for me as my moral responsibility for the client, sometimes I say, hey, we don't want to do this work, right? That's not a good idea for your client. So
Yeah.
I agree completely.
And I've had it the opposite, Miles, where the survey benefited the individual plaintiff and not the big company. So again, it goes to their, people want to have just easy black and white rules for what we do, but it's complicated. And there are a lot of factors that can make it go one way or the other. And part of mine and Miles's job is to understand those and try and bring some order to the chaos.
Yep.
Dr. Miles, it's so funny. You sound like an attorney right now. You spend too much time with him. The answer is always it depends.
Yeah, I would say Miles and I know just enough about the law to be incredibly dangerous. That is.
Okay, so you guys have talked about a jury questionnaire, right? So a written survey versus oral voir dire. Are there particular questions that you might phrase only in a circumstance where you're doing a jury questionnaire versus things that might be better to ask during oral voir dire?
Well, one challenge you have, a challenge you always have is that jurors are reluctant with some types of questions to give the answer, period, but definitely in open court, right? So one of the things you make sure that you have the attorneys tell people is, you can come up to the bench. But even then, if you're asking a question, have you or somebody in your family been sexually abused, who wants to stand up and walk to the bench, letting everybody know if it's not you, it's somebody in your family, and that's where a survey can be much better at finding those people than doing oral voir dire.
Right. So if you're an attorney, you want to convince folks, a judge to let you do a written questionnaire, because sometimes judges are hesitant, I would, say exactly what Stu said to the judge. It's a way to get people to be more honest and transparent. The other thing is, with a large jury pool, it's a more efficient way to be able to question all the jurors individually. And judges will sometimes judges will not be particularly sensitive to how embarrassing the questions will be and how hesitant. But when you say, oh, we'll get you through jury selection quicker, Your Honor, they'll sometimes react well to that. So that's another ploy I use, with my clients. You want to argue this to the judge regarding getting a written questionnaire.
And
That's awesome.
Something that just came to mind, and it kind of gets at a lot of what we're talking about and how complicated things can be. So I've done death qualified panels. And so you have a death penalty case, and they usually do that individual voir dire. And I think in the case I did, there were over 100 jurors, and it took more than a week. So every juror has to go to the bench with the judge, and you have to question them. And one of the big hurdles they have to agree to is that in some situation they would find the death penalty, because you can't be on a jury if you would never, give the death penalty. And what was interesting in this one case I did was one of the main reasons people said either they would or would not give the death penalty had to do with their interpretation of the Bible, right? So one happened to agree focused on one part of the Bible, an eye for an eye, a tooth for a tooth, that you had to give the death penalty, and others focused on other parts of the Bible, thou shalt not kill. And so I thought that, so then just, asking people, are you religious, would not be predictive of whether or not they would or would not, or even if they were Christian, whether they would or would not find in a death penalty case. So anyway, I thought that would be just kind of an interesting example of the complexities of what we do.
Yeah, I mean, it's really, you bring up a really like a poignant point with that, right? You really do have to dig in and get super honest answers out of everyone. Especially, I feel like in the world today, that climate has got to be even more polarized than it used to be. No one wants to offend anyone. It's really difficult to speak up and admit that you've got bias or no, I feel like it would be really difficult, like you had talked about earlier, doing that in open court, right? Where people can hear you and they can see you. But there are also sometimes that it's really important for you to see that body language reaction. How do you get people to be honest when they're answering some of these super hard questions?
Well, analogy I like to use is, and I'm sure Miles, you've done a lot of, getting cows into the corral up there in Boston. That was a joke, Miles. That's where you laugh.
I don't know how many cows we have in the corral, but I was just going with it, Stu.
But I'm from Louisville, and I haven't done it, but seen it done. You don't try to take, and I'm not saying that jurors are cows. This is just an analogy. But you don't try to take a cow into a very narrow opening, right? You funnel them into that opening, and it's the same with jury selection. You don't ask, "Can you be fair?" as the first question, because everybody's going to say, "I can be fair." You have to just slowly, build up the intensity of those questions. Who here would be even slightly uncomfortable, with blah, blah, a little bit. Again, the bar is so low, and then you just up it up. So you feel pretty strongly about that, don't you, Mr. Jones? Yes. And that's an opinion, Mr. Jones, that you've had for a long time, isn't it? Yes. And I doubt, Mr. Jones, over the course of a week's trial, that I or the judge or the other side is going to change you of that opinion, is it, Mr. Jones? No. Then you kind of get to, Mr. Jones, would you agree that because of your feelings that the other side has at least a slight advantage over my side just starting out in the case? Yes. So you can see, then you can get to that final questions, and you would still never say you can't be fair, because they're still going to say they can be fair, but you can at least get them to say the other side starts off with a slight advantage, and usually that's what it is, the trigger that can get somebody stricken for cause.
Right, and to tie this back to the kind of the title of our seminar again, or conversation, sometimes attorneys do the actual opposite, right? And they'll try to argue their case through questions, and it really doesn't work, especially when you only have like 20 minutes or so, right? You're not going to change somebody's long-held standard beliefs about corporations. But what they'll say is, don't you think blah, 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 or, you can be fair and impartial, can't you? And, it's an intimidating situation for a juror, so even they're way biased against your side, they'll often say, yeah, sure, I can be fair, whatever you say, basically. And you're not getting real information. The other common mistakes I see attorneys make is, again, they're focused on kind of presenting their case facts in the guise of questions, and they're not listening, right? Ideally, you would be doing a lot more listening than talking as a questioning attorney. And the other thing I find is jurors will sometimes not answer the question directly, but it will be, and then the attorney will just move on, but it will be something that's very important, right? So to give you an example, say it's an asbestos case, and you ask, did your, anybody in your family ever get cancer? And the person says, no, but, asbestos were everywhere in school, and they stop, right? So if the attorney's not listening, they're like, okay, check them off the list. They didn't have cancer. But when somebody brings up something that's not directly answering your question, it could still be valuable. So if I was in the real time with the attorney, I'd say, okay, hey, wait a second. They're starting to talk about asbestos in the schools. Follow up on that, right? So you really have to have an open mind as an attorney. You have to be listening. You can't just have a checklist and just follow it regardless of what your juror says. So Something that's, attorneys are not used to because they're used to following their case organization, case in chief, and they're very meticulous and organized. But sometimes the organization can even work against you. It's more being an interested listener in a non-intimidating way is a way to get out more information.
Yeah, and that, again, that's another good point, Miles, and it really gets at what we bring to assisting attorneys, because the attorneys are kind of real-time focusing, asking these questions, and it's very helpful, and I've had attorneys tell me this, having me there as an active listener, catching the things that they miss, writing them follow-up questions, reminding them to ask the juror number, bringing to their attention that somebody raised their hand and they didn't call on them, and having an extra set of eyes. And also, we're just really good organizationally at just keeping track of this information. And, what I'm working on, I've got a pad of paper and I'm working on my strike list. So when the attorney's done, I just hand it to him and I'm like, here you go. Based on my experience, I think you can argue these jurors be stricken for these reasons. And again, you want other people on the trial team and the attorney to add to that, or maybe I got something wrong, but that's a really helpful work product, that we include in what we do.
Yep.
That's awesome. I mean, gentlemen, we're coming up relatively close to the end of the time that we had allocated for this morning. I've got one more question I really wanted to ask. So, I mean, hopefully it comes up as a natural end to the conversation. And if it doesn't, we're going to make it anyway. But you guys both actually talked earlier, and what we were discussing earlier, you kind of talked about the differences in different venues and how things can really shift among demographics and different people groups, just regionally, right? Since race and income and all those different things are going to fit within that juror profile. How do things differ from courtroom to courtroom and venue to venue? I mean, do you do a different thing?
Are you saying in terms of the jury pool or in terms of how the voir dire process is conducted, Mike? In terms of, I'm sorry, go ahead.
Nope, that's all you.
Okay, the voir dire process varies a heck of a lot, right? So, if I had to generalize, I would say maybe the South you allow a much more fulsome voir dire process. Northeast on average, well, no, I mean, Connecticut State Court, you can go on forever. So what I would really say is it varies judge to judge, even within an individual venue, of what kind of voir dire process you're going to get. And again, in terms of common mistakes made, I have a lot of attorneys that are very hesitant to ask the clerk of the court or the judge, how is this stuff going to work? Right. And the more you can find out in advance, the more helpful I can be, right? So what I do is I encourage them with local counsel to find out how the judge has conducted voir dire in other cases that he or she has done. I encourage them to ask the clerk of the court, because the more you know in advance, the better I can be helpful to the client in a number of ways. So there's often certain types of questions that judge will not allow, so I need to know that when I'm writing the questions. Judges have their own standard questions. So you don't want to be redundant with their questions, especially if only a limited amount are allowed in the courtroom, right? So, these are considerations often in courtrooms. Then on the other hand, you sometimes have no consideration of that. You don't have to worry, like in Florida, I just did a case where you could ask, questions till the cows come home, to go back to Stu's cow metaphors here. And then you don't have to worry as much about what questions can get in, how to tailor the questions exactly, because everything's going to get in. So the only consistency is there is no consistency. So you really, attorneys need to try to figure out how it's going to work in advance, and then we can kind of adapt to the situation to be most helpful to them. Stu, you want to add stuff?
Yeah, and I think an important element of that, I'll give you an example of Kentucky. So in Kentucky, in Jefferson County, jury selection is done one way. And typically you'll have 45, 50, 60 people on the panel. And then you voir dire the entire panel. And then after you're done voir diring the panel, you do your motions for causal strikes. And then you do your peremptory challenges. Everywhere else in the state, with maybe a few exceptions, you might have a room with 50, 60, 80 people, but they only put 22 or 24 in a box. And you only question the people in the box, and you do strikes as you go. And if you strike somebody for cause, they come out, and then you pull somebody from the audience and you put them in there. Well, the way you ask those 4-hour questions and where you locate the cause questions may differ in those, right? Because you want to get the cause questions in that second example in the front end, because you have to re-ask those questions every time you put a new person in the box. And if you
And your strike strategy may differ too, it's not just the questions, right?
The strike strategy may differ. So it really is important to understand what are the rules, and also getting a seating chart. A lot of the courts have a way where they seat people. Well, if you know that ahead of time, they give you a little bitty piece of paper seating chart. I like to make a bigger one. So if I know the seating chart, I can make that in advance, and that gives me, an advantage over the other side who maybe hasn't thought of that. It's a lot easier to write down all this information, on a bigger piece of real estate than on a little bitty 8.5 by 11 piece of paper.
Right. I mean, that's sometimes what the attorneys forget again is, and not to rag on attorneys, it's not something they do that much, and they're focused more on presenting the case and things like that, is this stuff happens fast. So the better you can know in advance, you can, like Stu said, be organized and actually get the information. Because often, it's like a water hose, like a high pressure water hose, and you're just trying to get as quickly as you can the information, because the judge isn't going to go back and say, okay, nobody heard what 12 said, we'll redo that. Often the judge just wants to get the jury seated as quickly as possible, because he or she has a docket schedule to meet. So it's kind of our job to get this stuff in advance and figure out how are we going to best efficiently do this so we can get the most information about each potential juror.
Yeah, that's a good point, Miles. The average attorney, might, and let's put COVID aside, pre-COVID, might have tried 2 or 3 cases a year. Some try more, but I think on average, that would be a pretty good amount of cases they try in picking juries. Miles and I might have months where we pick 2 or 3 juries a month, or we might pick a dozen or more a year. And so just, we have our 10,000 hours in picking juries. And again, I'm not saying we're super great human beings, but you can't not have that experience. Having that experience just brings to you a level of confidence and just comfort and knowledge in doing this task.
All right. The salesperson in me thinks that is the best way that we can end this. To borrow the immortal words of Maynard James Keenan, we make our careers by not giving away the whole bag. If you joined us this morning and you found all of this incredibly interesting like I did, please feel free to reach out to your local U.S. legal support or DecisionQuest person. Thank you all for joining us this morning. Dr. Miles, Dr. Hutton, thank you for donating some of your time this morning to help educate those folks all across the country that are joining us. And I will leave you with that. Thank you all very much. Take care.
Thank you, Mike. Take care, Stu.
See you later, Miles.
Okay.